few moments.
Thank you, Councilman. And Councilman O, I'd like to recognize Councilman O.
Thank you very much, Mr. Chairman. I appreciate very much Councilman Taubenberger's resolution to have hearings and all the work that's being done. However, concerning my bill, I present a bill that I would like to have passed out of this committee with a favorable recommendation. The reason I say that is because we already have a criminal statute, and it's very clear. There couldn't be anything more simple or easy to understand or more relevant to the average citizen than someone violating their home, breaking into their home, entering illegally and unlawfully. We have different types of situations. Some are clearly landlord-tenant issues. Those are resolved in a civil court. Some are clearly criminal. Kicking in a door, breaking into a house, smashing windows. Those are clearly criminal, and the only entity that is designed to deal with public offenses like that are the police and the district attorney's office, our law enforcement entities. There's no other way to deal with that. Our civil system is not designed to provide appropriate justice in a private civil court hearing. For example, homeowners do not have a business license. They don't have a renter's license. They don't have a certificate of compliance. They don't have any of these things because they're not renting. They don't have a certificate of vacancy because their home is not vacant. And therefore, they go into a court system and clog it up with a matter that will take up to 16 months if they're lucky to remove a criminal. Before citizens take matters into their own hands, it's important that we clarify for our city, for our police, exactly what their responsibilities are. Taxpayers expect the police to do their duty. They are trained, they go through training, and they are supervised. Police do not simply arrest someone and conclude that they are guilty. The process is one in which they need probable cause, and it's a thing that they do every day. Let me start with my statement. Bill number 170827. A person who breaks into your home and refuses to leave is not a tenant just because they say so. That person is a criminal and should not be treated like a tenant without credible evidence. In obvious cases of burglary or criminal trespass, squatters should be arrested and prosecuted. In less obvious cases, there should be an expedited civil process. It should not take 9 to 16 months to remove a criminal from your home because you're forced to hire a lawyer and use a civil proceeding that is not designed to deal with criminal violations. In the meantime, you must continue to pay utilities and all costs. Even after these criminals finally leave your home, they are not punished with jail or fines. They do not pay rent or reimburse you for the damage to your home. It's not surprising that they often do it again. Opponents of my bill object because they say the police are not able to distinguish obvious cases of criminal trespass and fraud. Yet the police investigate murders and complex economic crimes, computer crimes every day. The district attorney's office can determine whether there's enough evidence to file criminal charges, and the courts can decide whether the evidence against the defendant is beyond a reasonable doubt. Today, there's a serious problem of criminals breaking into homes, falsely claiming to be tenants, and a failure in many cases by police to act because of arguments such as those that are being made by the opponents of this bill. Criminal laws are enforced by the police, prosecutors, and criminal court. Civil court is not designed to appropriately address criminal violations. Clogging up civil courts with criminal matters that do not fit in the system takes even longer than the regular civil cases and is burdensome to all. The argument that no one should be arrested because landlord-tenant relationships are legally complicated is completely wrong. Arrests where probable cause exists, as determined by a trained and sworn police officer, is the law and the standard. The arrest merely initiates a criminal process against the alleged offenders. Charges have to be brought by the police, approved by the district attorney's office, and found sufficient by the court. Only then can a trial begin. If at any point the police, DA, or judge determine there is not enough evidence that a crime has been committed, the criminal process stops. My bill does not, because it cannot, make the police arrest criminals. They should, and I urge the mayor to ensure that they do. What my bill does is help the homeowner who must deal with a criminal that is not arrested and remains in their home. It lays out a process that will expedite a civil hearing. While my bill lays out the foundation for that, I cannot make the court have an expedited process. The court is a separate branch of government, and they're not subject to my bill. They must decide to create an expedited process on their own. I've already met with the judiciary to discuss this. However, even if it happens, that process will not resolve this problem within 24 hours. Hopefully, it could take place within 30 days. But that will take more tax dollars for both the city and the courts in order to establish this system. But for criminal offenders who break into homes, the only process we as a government endorse is the police enforcing the law. Otherwise, you'll have citizens enforcing it by themselves, and that's not what we want. In these three separate instances, clearly a landlord-tenant issue, clearly a criminal issue, this bill provides some guidance to the police as to what is and what isn't acceptable in terms of the argument that I am a tenant. It does not apply to gardens. It does not apply to abandoned buildings. Abandoned buildings are already a defense in the state criminal code. This applies when there is evidence that a crime is being committed, but the police do not feel, or the district attorneys, that there's sufficient probable cause. In that instance, we create a expedited hearing, we have the identification, and we institute a fine. And what we have found in this process is that there are professional squatters who have money, who have homes, who have the ability to pay these fines, and what we're seeking is voluntary compliance. This problem has existed apparently at least for a decade, if not longer. And so the argument that we have just learned about this, I think, is problematic. In fact, I feel that we should take care of this today because it is long overdue. Thank you very much.
I'd like to call up the next panel. On panel number 2, I'm going to ask Jack Malloy, Kenny Barretts, and Roseanne Connor to come forward.
Morning. Chairman Dahman and members of the committee. My name is Jack Malloy. I'm the Government Affairs Chair at the Greater Philadelphia Association of Realtors. Thank you for the opportunity to testify regarding Bill number 170827 and Resolution number 170841. GPAR would like to thank Councilman Tolbenberger and Councilman O for inviting us here today. Additionally, we'd like to thank Chairman Dahm and his staffer, Jeff George, for working with us and the police department and the district attorney's office for nearly a year. They have listened to our concerns and have worked towards finding solving measures. We recognize that some folks are victims, as we heard earlier. We also know that some are complicit in their illegal activity. The latter often refuse to vacate a property and know how to plan the system. Meanwhile, the owner is victimized by going through an expensive and tedious process that denies them their fundamental property rights, including accessing or selling the property. I offer this squatting story that was shared by a fellow member who had an empty dwelling that was listed for sale. A buyer was found, an agreement of sale was executed, a final walkthrough was scheduled the morning of the settlement. The agent and the home buyer went to the house and found a family squatting in the house. Unfortunately, the sale could not be saved, and it fell through. A 9-month ejectment proceeding was pursued. The house was finally vacated, repairs were made, to the damage caused by the squatters, and it was listed again for sale. A new buyer was found for the property, and unfortunately, the same thing occurred. Squatters tied this house up for 2 years. This is just one, but there are many more stories. We understand that sometimes innocent people are deceived into renting properties by people who pose as fake real estate agents or owners. GPAR is committed to creating a safe city for homeowners and renters. Therefore, it's important to reduce the risks posed by squatters. We support the council's effort in addressing this issue. We welcome the opportunity to form a stakeholder group led by the council to be tasked with finding viable solutions. We also encourage, as we heard this morning, the Pennsylvania State Assembly to be a stakeholder in this same resolution. On behalf of GPAR, thank you for the time and opportunity to testify this morning. Thank you.
Thank you. Thank you very much. Ms. Connor, would you like to testify?
Yeah, hi. Hi, I'm Roseanne Connor from Connor & Connor. I am a real estate broker and appraiser in Philadelphia. I've been selling bank foreclosures specifically for 21 years, and I want to thank all of you for this. I have been dealing with this for the past 2 years. I had gotten some realtors together. I've had 23 incidents reported in the last year and a half. Of the realtors that I spoke to, we had 50 cases of this happening. It is scary for me when I go to the houses they're broken into. There's been a couple situations that I really wanted to bring out. There was one where we know that sometimes they break in and change the locks, so we check the houses constantly because they are bank properties. We went to the property and the locks were changed, we changed them back. The next day they were changed again, we changed them back. The third day they broke in at 1 o'clock in the morning and the neighbor said they were in there again. We went over there, they cut the gas pipe. And when we got there, when we first entered, the person went in first, started throwing up. That's how bad. The gas company was screaming and yelling at us. We had nothing to do because we thwarted their opportunity to get somebody in there. They went and did that, which was a row house with children all over the place, could have blown up at any time. We've had situations because of our properties, because they are vacant, a lot of times no utilities. We had one we went in where people said they rented it, they sublet the basement to a woman with 2 small babies. The baby was 8 weeks old, laying on the floor in a wet basement with no utilities. She had a TV, a portable TV, and a diaper bag, and 2 babies laying on a blanket in the floor. When I went in and put the light on, it scared the heck out of us. I almost had a heart attack. But she said they sublet it to her. Some of these properties are dangerous, and I want to say when we call, a lot of these situations are not reported because we wait for the police anywhere from 2 to 4 hours. I usually give up between 3 and 4 hours. I understand it is not an urgency for the police, and when the police come, they are very nice to us. But the waiting sometimes is 3, 4 hours, and then I just leave. So they're never even reported. It is so frequent. It happens so often. I have 2 right now, one in Juniata. People have been there for almost 10 months. Water bill, $400 a month. I knocked on the door. I said, what are you doing with the water? Are you filling a pool? Like, why are we paying this high bill? She said, do I look like I have a pool? And slammed the door in my face. Now, again, we called the police. The situations are so out of control. I want to say that when we call the police, we always have a tax record showing that we have proof of ownership. Secondly, we have a statement saying that we are the agent for the owner. I have a statement just saying that I am the agent for the owner. And we have a rental license, a vacant property license on every one, except the ones where it happens so soon, we can't get a license until the deed's recorded. So we apply on every one immediately as soon as we can. Having proof of who we are, having sometimes writs. We've already done an eviction. We go there, knock on the door, and still the police said they can't take us out. We also offer these people, to add insult to injury, we offer them an average of $2,500 to leave, the squatters, and they say no because we can be here for so long. that we don't have to do that. I mean, it's insult to injury. It's dangerous for us. It's dangerous for the people moving into these houses that are not fit for I had one lady said she rented and she said they told me if we get evicted during the time we're here, they'll give us a free property. After, they'll give us another one, they'll transfer us. No one would question why you would be evicted from a house that you're legally renting. One lease, and final, because I don't want to go on too long. One lease actually said it was between the tenant and the landlord. The landlord's name was Real Ator, 2 words, Real Ator. Like, and the police, even the policeman said to me, like, who actually would believe this? So it is scary for us. I go into houses that have been broken into. I don't know if they're in there. We can't call the police because they can't do anything. And I've been living with this for almost 2 years. I've had 23 situations in the last year and a half, and I just want to thank you all for whatever you can do. I really, really appreciate it.
Thank you for your testimony.
Thank you.
Mr. Barretts?
Good morning, Mr. Chairman, members of council. Initially, I would just like to thank Councilman O.
You have to identify
Councilman-
yourself. Just identify yourself for the record.
Oh, I'm sorry.
That's okay.
Ken Barretts, I'm an attorney here in Philadelphia. I want to thank Councilman O, Councilman Tolberberger, and State Rep John Taylor for finally taking some action to address this issue. Councilman O, you made one statement, I don't want to hold it against you, but you made a mention that this may be a problem that has lasted approximately a decade. I've been dealing with this issue for many decades. I've been around for a while, and I represent landowners who have had to suffer through this problem. People breaking in to an unoccupied property and setting up shop. Anyone who breaks into a property has committed a crime. I understand your ordinance doesn't address the criminal aspect of this. I can assure you that the civil courts do not adequately address this issue. This is not a situation, and your ordinance does not address legitimate tenants who occupy a property. It does not address someone, sadly, who may be the victim of domestic violence, because that individual, generally or ordinarily in the confines of this argument, is a legitimate tenant. This addresses an unscrupulous individual who has somehow or another managed to break into someone else's real estate. The process through the Court of Common Pleas currently can take upwards of a year, even longer, depending upon the circumstances. The financial burden on the legitimate owner who has done nothing wrong is obscene. Not that my fees are obscene, but the whole idea of what is going on. And more importantly, or perhaps just as importantly, we're dealing with possibly the theft of water and sewer, or water from the city of Philadelphia, the theft of PGW services, the theft of HAPCO services, certainly the potential for violence where a legitimate owner comes upon his or her own property and finds an unauthorized occupant there, where the police obviously don't want to get involved and or won't get involved, and now what is one to do under the circumstances? This is not something that promotes some sort of unfair action or tactics against legitimate tenants. It does not protect the unscrupulous owner who comes forward and says, hey, someone broke into my property when in fact there may be a legitimate tenant. I think we need to have the safeguards that have been suggested. I think there's a procedure that needs to be put in place. I think we need the cooperation of the Court of Common Pleas to entertain expedited hearings. Again, we're not talking about municipal court, which is the court of initial jurisdiction over landlord-tenant relationships. This is something far outside the landlord-tenant realm. So I appreciate the opportunity to be here. And couple other thoughts, and that is what sometimes falls through the cracks is that these situations lend itself to a declining or eroding tax base and a declining, eroding housing stock. So the very people who might benefit from having safe, secure properties, these are properties that end up being destroyed, pipes being removed, all the way down the line, all these different problems, and it does not help the city of Philadelphia a little bit. Something needs to be done. Thank you. I appreciate the opportunity.
Thank you. Thank you for your testimony. So, Ebony Griffin, why don't we start with your testimony?
With who?
Me.
I'm going to start with Ebony.
Good afternoon. My name is Ebony Griffin. I am a staff attorney with the Public Interest Law Center. I work to promote environmental justice and also lead our Garden Justice Legal Initiative, which provides pro bono legal support, advocacy, and policy research to community gardens and urban farmers in Philadelphia's communities of colors, immigrant and refugee communities, and historically disinvested neighborhoods. I planned initially to come and offer my support for Resolution 170841 and to talk about some of the concerns that I had that that bill number 170827 could potentially pose for urban gardens. Upon my arrival this morning, I learned that Councilman O planned to amend that bill to include an exemption for garden space. So that really addresses a lot of my major concerns with that portion of the bill. So in the interest of time, I've already submitted my written testimony. I'm not going to waste anyone's time on that.
Thank you very much. That was great. Mr. Spear.
Thank you for allowing me to testify on behalf of HAPCO. My name is Harvey Spear. I'm president of the Homeowners Association, which is known as HAPCO. We're the largest organization for the provider of low and moderate income private rental housing. HAPCO's membership owns primarily single-family and duplex rentals on the streets and the neighborhoods of Philadelphia. As we have seen reported in the news, the problem with squatters keeps growing in Philadelphia. Squatters currently occupy properties without rights or title, with very little consequence for doing so. Oftentimes, after a property becomes vacant, an opportunist squatter breaks into the property and begins to live there. Although they have no legal right to stay, the police will not force them to leave. The owner has to hire an attorney and file an ejectment action in the Court of Common Pleas. It may take many months and sometimes years to go through the legal process as it stands today. Essentially, the squatter has more rights than a tenant with a valid lease. Councilman O's bill is a step in the right direction, and HAPCO supports it. We applaud both Councilman O and Councilman Al Tottenberger in taking the lead on such an important issue. One minor request would be to amend the bill to allow the owner of a property to immediately be able to file an expedited hearing without first going to the police. There are many situations where an owner keeps the squatter, where owner knows the squatter is not going to leave, and requiring the police to go to the property before being able to file in court and may escalate the tension. Thank you for allowing me to speak on this important issue, and I'm available for questions. I just want to add that personally I have not had a problem with squatters in my ownership of properties, except for 25 years ago where literally it was a disaster. I owned a property on Vine Street. I walked in and there must have been 20 people lighting fires. I walked in, I got chased out. Eventually the property caught fire and we had to demolish it. And I don't think anybody got hurt or anything like that, but my experience is one that I'll never forget from 25 years ago. Thank you for allowing me to testify.
Thank you. Thank you for your testimony. Victor, you're going to testify?
My name is Victor Pinkney. I'm first vice president of HAPCO. Originally, I was not going to speak today, but after hearing testimony from both sides, we all seem to be after the same thing. But one thing that nobody's addressing, the time period that it takes to get a property back. That means that's one more house because most of this takes place in low to moderate income neighborhoods. The city of Philadelphia has a shortage of low and moderate decent housing. So now, and these squatters don't generally, they don't take the border, they go to a boarded up place, but it's generally the ones that's being rehabbed. So that means that property is now off the market for anywhere from a year to a year and a half. That's all, so something should be done.
Thank you.
I just want to add, if it's possible, that it's not an easy solution, and we are not here to advocate anything to City Council. We're here to accommodate you and to try to come to a solution. I know it's a difficult one because the police have no way of knowing who somebody is. My leases are all written leases. I know with an oral lease something, it could be ambiguous. So we're not here advocating to throw this bill down everybody's throat. We would like to see a solution where it benefits everybody.
Thank you. Thank you very much. And Phil Lord.
Yes.
Thank you for your patience.
Thank you for giving me the chance to do this. I know it's been a long day. My name is Phil Lord. I'm the Executive Director of the Tenant Union Representative Network. We assist thousands of tenants each year. We see them in our classes and our one-on-one counseling. And we see this problem from a different viewpoint, as you can imagine. First of all, I want to set a context, and I'll try to be brief. Philadelphia is on its way to being the eviction capital of the country. It has the highest eviction rate except for Miami. And that means that we put more people out than any other major city around except Miami. And with this law, I'm convinced we'll be way ahead of everybody else. Let me tell you why. According to Matthew Desmond, who was a scholar on evictions and wrote the book on it literally, 2/3 of the evictions that take place, forced evictions in the city, his city that he was talking about, Milwaukee, but he says this is true of the country generally, are not going to court. Right now, 24,000 cases are in court. That means 48,000 evictions are taking place in Philadelphia, if it's typical, without court process. This bill will make evictions without court process very easy to do. There are no safeguards for tenants in this bill. If a landlord lies, there is no penalty. This is outrageous. This is going to hurt a lot of people. They're going to go down to the landlord's going to go down to the police station, say, I didn't put this person in. They could have given the person permission to go in the property yesterday and go the next day down to the police station and say, I didn't do it, and the person's on the street. Now, you may think that's far-fetched, but we see people, for example, young women who are moved into properties, and because they won't provide sexual favors, the landlord says, get out. Okay, get out now. The people that were referred to earlier, who were, and I think they were the people referred to earlier, came to our office long after they were in trouble. They were tenants. They came, they paid $4,200 to somebody, Craigslist person, gave them money, moved in, had 2 little kids, thought that was their home. When you give $4,000 to somebody, you have no money to move anywhere else. They found the name on Craigslist. They found out later on, according to people, that in fact they shouldn't be there. We told them, you're in trouble. You're going to get arrested. There's no one saying here today that the police can't arrest all the sad stories we've heard. The police can go, even after the court case has gone through common pleas and everything else, they can still arrest those people and lock them up. We're not saying you shouldn't do that. We think you should. Anyone who's stealing property or abusing elders or taking advantage of women and doing sexual violence, they should be arrested. No two ways about it. But you can't do this thing, which looks like it's going to close a door and open up a huge door that's going to say people can just go down and file an affidavit and evict their tenants. Who's going to go to court? Why am I going to go to court? Court costs money. I can go down to the police station. And let me say this. This bill seems to be premised on the notion that people don't know whether squatters are tenants or tenants are squatters, and they say the police don't know what to do. This is based on an assumption that the police don't know what they're doing. I don't believe that, but that's the rationale for this bill. And then it goes on to say that there's going to be a rebuttable presumption. How in the world can police who are having trouble figuring out what to do in enforcing a criminal statute, a third-degree misdemeanor, which is called trespass, which is clear as day. If you break into a property, you go to jail for up to a year. It's that simple, okay? It's not complicated, okay? How can police who you're saying are having trouble do that resolve property issues, title issues, issues around lease fraud, and on a street curb corner, okay, and resolve that fairly and equitably. These things are in court because they're complicated, that's why. And if their lawyers don't know how to get injunctions, get people out right away, that's their lawyer's problem. They really are ways to deal with this problem. Police can go in there and arrest people, and they should be able to do that, and we think we support that. But this law doesn't add a thing to that power and creates a lot of confusion around what's civil and what's criminal. This law provides 90 days in jail. If you don't think that's criminal, then you got a different concept of criminal than I have. 90 days in jail. If that police officer says get out in 48 hours and you don't, you're in jail. What's not criminal about that? How in the world are we talking about not criminal? So let me say this. You may disagree with me. And like I said, I've seen the other side. I've seen like a young couple, 20 in their early 20s, had 2 twins, beautiful young couple. They gave all their money to someone to rent a property, and then they found out the person didn't own the property, and now they had to leave right away or else get arrested. There is nothing in this city that enables a person who's being tricked on Craigslist to find out who is the right agent for the property. There's no way to find out if this person talking to you is really a relationship with the owner. And so you are vulnerable because there's no system to being tricked and scammed that way, and that's what's happening a lot, okay? But let me say this, bottom line is, this is a complex problem. The resolution about this conversation says that. If you rush this thing through, you're gonna be making a big mistake because, believe me, this is complicated, it has backlash that we can't even understand right now.
All right, thank you very much for your testimony. Thank you.